What is an occupation order? An occupation order is a weapon available to the courts under the Family Law Act 1996. It allows the court to regulate the occupation of the family home. Occupation orders can exclude someone from the family home. They can also be used to enforce the right to remain in occupation of the property, require permission to enter and remain in the property, regulate the occupation of the property, prohibit, suspend or restrict the exercise of occupation in the property, require the departure from the property, exclude from a defined area in which the property is located. Such orders are granted in very serious circumstances, as it can exclude someone from the home in which they are legally entitled to live, i.e. they jointly or solely own the property. For this reason, understandably, there are strict tests for such an order to be granted. The applicant must have a legal or contractual benefit in the property or a right to occupy. This includes circumstances where the applicant is not necessarily named as an owner of the property. However, they have matrimonial home rights by virtue of the marriage and occupation of the property as their home. The property is or has been at some time the home of both parties and was intended to be their home. The parties must be associated as set out within Section 62 to Section 63 of the Family Law Act 1996, i.e. a spouse, civil partner, cohabitee, relatives, people who have agreed to marry, have had an intimate personal relationship with one another of significant duration. The list is not exhaustive. When making an application under the Family Law Act for an occupation order, the court will consider the balance of harm test. The court's duty is to balance the harm which would be suffered by the applicant or child if the order is not made against that of the respondent if the order is made. If in the absence of an order, the applicant will suffer significant harm, the order must be made unless it is proven for the harm suffered by a respondent would be greater if an order is made. If this test fails, then the court does have the discretion to make an order anyway. In deciding whether to grant an order of occupation, the court will have regard to the housing needs and housing financial resources of the parties and children, the likely effect of an order made, including the health, safety or well-being of children, and finally, the conduct of the parties. We can discuss this in conference and work out the best strategy for you with regard to pursuing an occupation order, should this be in your best interests.